The court just changed everything. If you carry, if you train, if you believe the Constitution still means what it says, then what just happened in the Supreme Court affects you directly. A 6-3 ruling didn't just tweak the law, it rewrote the rules for gun owners in all 50 states. From permits to training requirements, from background checks to constitutional carry, the entire legal map has shifted. This is more than headlines. This is the front line. And if you don't understand the new rules, you could be caught off guard when it matters most. So hit that subscribe button, stay alert, and let's break this down, one rule at a time. Because what you don't know can cost you. Weapons Law Advisors here to make sure that never happens. Chapter 1. The 6-3 decision that lit the fuse. The Supreme Court's 6-3 ruling dropped like a legal bomb. It didn't just decide a case, it sent shockwaves through every corner of firearms law. At its core, the question was simple. Can a state force law-abiding citizens through months of delays, excessive fees, or just cause requirements before they can exercise a constitutional right? The court said no, and in doing so, it reinforced and expanded the Bruin precedent from 2022. This ruling now stands as the new anchor for every Second Amendment legal battle moving forward. It reaffirms constitutional carry as the baseline standard, meaning that any law requiring proof of need or government permission slips now stands on shaky legal ground. The court once again emphasized historical tradition as the key test. If a modern law doesn't align with America's historical understanding of gun rights, it's constitutionally suspect. With this one decision, the court reminded every state, the Second Amendment is not a second-class right. It stands shoulder to shoulder with the First, the Fourth, and every other fundamental freedom. Chapter 2. May issue permits on life support. Before Bruin, states like California, New York, New Jersey, Hawaii, and Maryland used may issue systems for carry permits. That meant even if you passed a background check and completed training, the state could still deny you, simply because they felt like it. This ruling directly attacks that philosophy. The court declared once again that subjective discretion has no place when it comes to fundamental rights. New York's good cause standard invalidated. California's sheriff approval hurdle on the chopping block. Hawaii's and Maryland's restrictive systems now under direct constitutional fire. Going forward, courts must demand historical analogs and not modern political preferences to justify gun restrictions. Every state now faces a legal reckoning. Revise the law or watch it get dismantled in federal court. For gun owners, that means your rights don't stop at your county line. Chapter 3. No more delays. One of the biggest hidden weapons used by anti-gun states? Permit delays. 3 months, 6 months, even a year in some jurisdictions. That's not enforcement, that's obstruction. This new ruling calls that out directly, framing the right to carry as immediate and active, not something you have to wait to use. You don't wait 8 months to use your freedom of speech, and you shouldn't have to wait to defend your life. Courts are now reviewing these time-to-permit delays as potential violations of the core right to self-defense. Lawsuits have already been filed in Illinois and Massachusetts, with more coming every week. Fast-track injunctions are being sought to force states into compliance. The clock just became the enemy of anti-gun regulation. If a state drags its feet, the courts can, and likely will, strike it down. Chapter 4. Mandatory training under fire. Gun control advocates love to use mandatory training as a way to limit access. But the court didn't stop at permits. It went after the training mandates too. The question, can a state require extensive, expensive, or time-consuming training programs before allowing you to carry? The court's answer, if it wasn't historically required, it's constitutionally questionable. Modern mandates for classroom hours, range certifications, or costly renewals are now being tested against historical precedent. That's bad news for states like Maryland, California, and Connecticut, where strict multi-step training laws are common. Courts are now examining these requirements for cost, complexity, and delay. This doesn't mean training itself is bad. Responsible gun owners should train. But the government cannot make training a barrier to exercising a right, especially not when those barriers include $500 courses, multi-week waits, and limited class availability. Chapter 5. Background checks must be instant. The ruling doesn't remove background checks, but it sends a serious warning. They must be fast, fair, and consistent. Delays caused by NICS system errors, pending reviews, or redundant state-level holdups now risk violating the new timely access standard. The shift is simple but profound. You don't have to prove your innocence. The government must prove your ineligibility, and do it quickly. Pending NICS checks that extend past 3 business days, they're now under scrutiny. States adding extra background layers, like California's 10-day wait, or Washington's permit-to-purchase system, may face constitutional challenges. The court's message is clear. Background checks can exist, but they cannot become tools of delay or denial. If the system can't deliver results fast, it can't be trusted to gatekeep your rights. Chapter 6. The Collapse of Training Mandates. For years, certain states have layered on mandatory training as a way to limit carry access. But after this decision, that entire concept is legally unstable. The court made it clear. When prerequisites become excessive, they cross a constitutional line. 16 hours of classes, weeks of waiting, hundreds of dollars in costs? Courts are now viewing that as an infringement, not a regulation. States like Maryland and New York, which require up to 16 hours of training and multiple renewals, are under pressure. California's complex multi-step process could also face rollback. Some states may soon shift from required training to recommended training. The message is simple. You don't need to jump through hoops to exercise a fundamental right. Chapter 7. Background checks and historical limits. No, the ruling doesn't erase background checks entirely, but it forces a hard question. Were these kinds of preemptive screenings historically justified at the time of the founding? Some justices noted that the founders didn't require pre-clearance to exercise a right. That means universal background checks, extended waiting periods, and may-issue purchase policies could now be vulnerable to constitutional challenge. If the government can't show a strong historical precedent, it loses the argument. Chapter 8. Federal versus State. Who's really in charge? This decision sparked a fresh debate over power. When state laws contradict the Second Amendment, who wins? The court's message was unambiguous. Constitutional rights do not stop at state lines. States that continue to pass restrictive laws now risk immediate federal intervention. Even federal policies are being examined under the same originalist standard. Expect to see a wave of new cases fast-tracked to the Supreme Court. This decision isn't just theory, it's already reshaping the balance of power across the country. Chapter 9. The Bruin Reborn. You thought New York State Rifle and Pistol Association vs. Bruin was a landmark. This ruling builds on it and cements it. Bruin established that the government must prove a law aligns with historical tradition. Now, that principle is stronger than ever. The Bruin test is no longer guidance. It's judicial armor. Every new gun law will be measured against it, and any law that fails that test is on borrowed time. States can no longer rely on modern fears or policy arguments. They must show direct historical support or face defeat. Chapter 10. What happens next? This isn't just a court decision, it's a cultural reset. Gun owners, lawmakers, and activists across America are recalculating their next moves. Pro-gun states are expanding constitutional carry. Gun control states are scrambling to rewrite their laws before lawsuits pile up. The ATF's next moves will be closely watched, especially after recent controversies. Expect new legislation. Expect new challenges. Expect the fight to move fast. The Supreme Court didn't just issue a ruling. They fired the first shot in a constitutional revolution. For years, gun owners have played defense. But after this ruling, the tide is turning. The court has spoken loud and clear. Rights don't wait for permission slips, and the burden is now on the government to justify any restriction. If you believe in real reporting, legal truth, and staying one step ahead, hit subscribe, stay sharp, and stay free.